Making a joke. Okay, here we go. I want to basically do two things today. You all know that I'm the author of a book on drunk driving in New Jersey, and I've utilized that book as kind of like a counterpoint to what I see going on in municipal court with attorneys representing clients in drunk driving cases. And I see them all over the state. I'm really kind of a statewide attorney in that regard. I go to all 21 counties. And I would never second guess whatever arrangement an attorney privately makes with his client, okay? Having said that, though, I see so many things happening that are clear mistakes, very common, and I want to talk to you about them today so that we can kind of explore them together, and I'll get your input, too, in terms of you can think of alternative ways of handling these things so you guys don't make these same mistakes. Okay? Everybody cool? All right, let's get started then. And I want to begin with just some basic stuff. The number one mistake I see among attorneys in New Jersey is a lack of aggression. Now, in a way, I feel bad for the public because when they look up the name of an attorney in the phone book who's going to represent them on a drunk driving case, and you can say all the crazy stuff you want in the phone book about, that you defend drunk driving cases, but that doesn't mean you have any experience or knowledge or skill set to be able to do it properly. I suspected that's one of the things the Supreme Court wanted to accomplish when they created the Certified Municipal Court program, so that the Certified Municipal Court trial attorneys are tested on their ability to do drunk driving cases. In fact, it's really very much geared toward drunk driving more than anything else that you would do in municipal court. So a member of the public who calls up an attorney who's been certified by the Supreme Court as a trial attorney has some indicia of competence with doing drunk driving cases, but you don't get that with everybody in the world, and you have varying degrees of knowledge and talent, so to speak. So, the number one thing I see is a lack of aggression. Now, by that I mean, what is the downside to taking a .09 case to trial? Okay? If you're not in a school zone, it's a first offense, what's going to happen to you? What's the worst that could happen? And the answer? Well, Michael, you tell me. What's the worst that could happen? Yeah, well, and if you plead guilty, what's going to happen to you? All right. So there's really no justification for not trying those cases because there's no downside to it whatsoever. The only thing that may come back at you is some kind of a threat of a trial tax, and we're going to talk about that in a moment. You may run into that with a defendant who has a reading that's excessive a point, it's going to be .10 or higher. But for the person who's just a .09, unless you're dealing with a school zone case, there's no downside to trying it. Where there is a school zone, then of course it becomes a major downside to trying the school zone case. Next, unless there's a companion refusal charge, there's no downside to trying a second offense. What's the worst that's going to happen? They take your license for 2 years, one way or the other. It's nothing they can really do to you. You have a tremendous incentive, though, to plead guilty where there's sufficient evidence either on the refusal or on the drunk to plead guilty to one of them, because if you don't, it's mandatory consecutive sentences for the DWI and the refusal if you plead guilty or get found guilty of both. So the legislature intended that as kind of a hammer to get people to plead guilty. Very much the same thing with the third offense. What's the worst that's going to happen? They're going to put your guy in jail for 6 months? That's where he's going anyway. If he has a drunk and a refusal, you have a tremendous incentive to try to plead out to the refusal if you can. Getting found guilty of both, once again, is going to require a consecutive suspension of, it's going to wind up being 20 years of license loss. So, in those situations where there is no refusal on the second offense, try the case, all right? Now, I want to talk a little bit about prosecutors and trial tax, all right? And I don't mean any disrespect to anybody in particular, but I'm just telling you from my own experience of doing this for a long, long time, all over the state. The dirty little secret is that the vast majority of prosecutors have no idea what they're doing. They don't know how to try a drunk driving case. And there's multiple reasons for that. One reason is inexperience. Another reason is lack of training, lack of support system, and really no incentive to spend the time necessary to really prep cases and get them ready to go. Most of the cases plead out primarily because of lack of aggression. And what you're left with are prosecutors who really, at the end of the day, are not particularly experienced in trying drunk driving cases. And you'll never know this until you start trying it and you find out how weak they are in terms of what the proofs are, how to cross-examine witnesses, how to do a direct examination of witnesses. And what you'll really find that's shocking is they have no idea about how to put the Chun proofs together, okay, let alone get them in evidence. So a lot of this is just bluff and bluster in my own experience. And when you take them to trial now, you really force the issue. I can think of where that would occur, at least in terms of the drunk driving, because every other suspension is kind of set, would be either for any school zone case where there's a range in school zones, but for the first offender, okay? So a guy can lose his license between 7 and 12 months, and the prosecutor says, I'm going to tell the judge to take the license for 12 months, and he will do it, okay? So you're going to punish my guy for going to trial, is that it, you know? If they start with that, you come back, and a couple things you may want to do. First is you may want to go right to the judge before the trial starts and call the prosecutor out on it. Say, the prosecutor's told me that you're going to tax my guy if he takes the case to trial and gets found guilty. Now, if that's true, I'd like you to recuse immediately because you've prejudged a case before you've heard one syllable of evidence and decided that he's going to be punished merely for taking his case to trial, okay? If that's not the case, then I'm going to expect you to follow New Jersey law as set forth by our Supreme Court in not one but two different cases. And these are the cases. It's State versus Palma. And I was going to say Monzo is not the right case. Moran, okay? Now, I suggest that you take this list with you to court every time that you have a drunk driving case. Moran lists the aggravating and mitigating factors that judges should consider when they're making the dual determination of A, am I going to take a driver's license in the first place, and B, if I do, how long is it going to be for, all right? Now, in drunk driving, the decision about whether the license is going to be taken has already been made by the legislature. But in those isolated instances where there's a range that can be imposed, the judge has to base the range on the Moran factors, okay? You just basically weigh them and evaluate them, and then when the judge puts them all together, he's supposed to be able to come up with a number, all right, which will be ranging between 7 months up to whatever the maximum is. One of the things I want you to be particularly careful about is double counting of aggravating factors. This is true when your client has a somewhat elevated BAC. Let's say he's a 0.17, 0.18, 0.19, something of that nature, all right? If the judge says I'm going to take his license for extra because he was a 0.18 or 0.19, you've got to object. You've got to jump all over that. Same thing if the prosecutor brings it up. It's illegal. It's double counting, and it's an element of the offense. You can't double count something that's an element of the actual offense, all right? The only relevance that an elevated BAC would have ever in a drunk driving sentencing would be on the following, okay? The nature and extent, the character and attitude of the defendant indicate that he or she will be likely or unlikely to commit another violation. So an elevated BAC is circumstantial proof that he may commit another violation in the future. And let me see. Wait a minute, there's one more. The character and attitude of the defendant indicate that he or she will be unlikely or unlikely to commit, here it is, the one before it. Whether the nature and extent of the defendant's driving record indicates a substantial risk that he or she will commit another violation. So that in combination with a high BAC, and maybe you have a situation where he's getting a step down, he's a first offender because of having a step down, those two things together would be an aggravating factor. But the mere fact that somebody had an elevated BAC or whatever's BAC, in and of itself is not an aggravating factor. You couldn't do it because it's an element of the offense. Everybody got that? All right. It's just an additional piece of evidence to be included among the the case law required aggravating and mitigating factors. A couple of additional ones that I want to talk to you about. One of them deals with hardship, okay? See where it says here, whether license suspension would cause excessive hardship to the defendant or his dependents. Hardship is definitely in play. There are three additional areas where hardship is a factor. You can get hardship consideration on drug offenses now, plus paraphernalia offenses. You can also get hardship consideration when you make an application for conditional discharge. And finally, there's a statute. It's 2C45-2C, which is a statute allowing judges to suspend driver's licenses for individuals who commit motor vehicle offense or commit a criminal offense by use of a motor vehicle, judges can take their driver's license for a period of 2 years if a motor vehicle is used in the commission of the offense. But again, the judge has to consider hardship. What impact is my taking the driver's license away going to have on the defendant? Now, you start with the proposition that every license suspension is going to work some level of hardship on the defendant and his family. What you've got to do is make the pitch for an excessive hardship, okay? How is this going to impact on mother, brother, sister, getting to work, going to the doctor, whatever individual circumstances you have? That can be a very powerful limiting factor in terms of how long the judge is going to take the license for, okay? So this is what you should be arguing in the event that there's a conviction and you have some range of punishment after trial and the prosecutor wants to beat up on you because you had the temerity to take your guy's case to trial. All right? There's the 2 sites on Moran. Palma deals with jail, and it's just as relevant for situations where a judge wants to put your guy in jail on a second offense for more than the mandatory 2 days. The aggravating and mitigating factors in Palma dealt with a situation where there was a homicide coming out of a careless driving case, and there was an application by the state to lock the driver up for a period of 15 days, and there had been no case law on this guiding the discretion of judges to impose jail sentences in careless driving cases. So the court said to adopt and utilize the same aggravating and mitigating factors. So if somebody starts talking about locking your guy up on a first offense or for something more than 2 days on a second offense, you go to these factors and argue them. Everybody got that? Okay, very important. Next big factor I see is a complete lack of preparation, sometimes embarrassingly so. One thing, it's a little thing, but it can be very important on occasion, is double checking the Chun calculations. Now look, if you see readings of 174, 174, 174, and 174, there's not a whole lot to check, all right? But once you start seeing breaks of that might be 0.05, 0.06, 0.07, and certainly if it's 0.10 difference among readings, you get one spurious reading, you got to work the numbers again. The case law allows you to work the numbers out to 4 significant decimal places. But I have to tell you, it's happened to be more than on one occasion that the sheet that they used for the state police did not correspond to what the actual numbers were when you go to calculate them. That took the readings out of evidence because they weren't in tolerance anymore, and as a result, I had one client, she walked away from a third offense, at least be sentenced as a third offender. So when you have those types of deviations, you should eyeball it, but if you start seeing some deviations, trust but verify, okay? Matching up TUN documents and relevant expirations. I see this an enormous amount. There are 3 expirations that you should be checking in every case. The first is the expiration on the card of the trooper who changed the solution every 6 months. That is a core foundational document under State versus Chun. It's got to go in evidence. The second is the card of the officer who performed the test on your client. That, again, is another core foundational document, and you should be looking at it. The third card, although you get it as part of Chun Discovery, is not a core foundational document. It is the card of the local police officer, if you're dealing with a local department, who last changed the simulator solution. Now, typically the simulator solution will last for 25 drunk drivers or 30 days, whichever happens first, and then the simulator solution has to be changed. Normally, the chief will task 2 or 3 different officers with that responsibility. You'll get their card in the discovery package. Make sure the card is not expired. Now, the card lasts for the calendar year you're in plus 2 additional calendar years. So assuming somebody got approved in September of year 1, he's good for the rest of year 1, then all of year 2 and all of year 3 expiring on December 31st of year 3. So all these cards always expire on December the 31st, okay? If the card is expired on the date the person administers the test or changes the solution, the results are inadmissible. Let me give you the New Jersey Administrative Code provision that says that. It's NJAC 13:51-1.8D, as in drunk driver. This NJAC code provision renders the results of tests performed by an officer whose card has expired inadmissible in evidence. Okay? Now, I think you have a much better shot of having a local police officer's car be expired than you do of a breath test coordinator. You should look anyway. But it happens fairly frequently, okay? And when you see that, you got to jump all over it. The problem that I see is people just don't look. They don't know to check it. They don't understand the significance of it. And think about it in the context of the person who's actually changing the solution every 2-3 weeks, whenever it is. If this person's card is expired, not only is your client's result not admissible, but anybody else who has tested on that instrument, it's not admissible either. Okay, that could be conceivably as many as 25 drunk drivers that all are in jeopardy now, because all the tests that were administered on that particular Alcotest, since he last changed the solution, he had no authority to change the solution on an Alcotest. Everybody see the significance here? Now, another major error in terms of discovery review is not matching up numbers. Start with the AIR and make sure that all the other documents that are going to go in evidence as part of the core foundational documents come back and match up with the alcohol influence report. The number one error that I see that doesn't get picked up by the defense attorneys is that the simulator solution control number doesn't match up with the simulator solution state police forensic laboratory test, okay? So you have a state police forensic laboratories test that says this particular simulator solution was checked by the state police forensic laboratories. It has the right amount of alcohol and water in it, and it's serial number ABC123, okay? Looks pretty good. And then you look at the alcohol influence report, and it references ABC456, okay? That's an issue that you're going to have to be very, very careful about. Now, how you handle it at trial is another matter. But you're never going to know to raise it in any context unless you actually check it ahead of time. So you'll be checking all the core foundational documents to make sure that they tie in to the alcohol influence report. Right? Okay. Make sure it's signed too by the cop. Let's see. Not reading police reports. I'm involved in a case right now where I don't think either the prosecutor or the defense attorney read the police report. They went into court, put a plea in, and the defense attorney asked for a civil reservation, and the judge says, "Oh, what are you talking about? Is anybody hurt?" And the defense attorney says, "Well, Judge, I'm not aware of anybody who was hurt. I don't know." And the prosecutor says, "Well, Judge, as far as I understand, it was a one-car accident. Nobody else was hurt." So the judge sentences the guy, all right? 3 months later, the prosecutor's office now wants to indict the defendant for aggravated assault because people were hurt. And the judge was misled by these two guys. I don't think either one of them read the report over, and they kind of just didn't properly inform the judge. Now, over and above any ethics issues you have here, it's the prosecutor's responsibility by statute to inform the judge in the beginning of the case about the existence of injuries or death associated with the drunk driving case. This way the judge can take the appropriate action to send to the prosecutor's office, or at least have the victims come into court so they can participate in the process. I'm just absolutely amazed at the number of attorneys who don't read the reports over and don't look at the videotape with their clients. That's another problem. You're crazy if you don't sit down with your client and let your client see exactly how drunk or non-drunk he was when they videotaped him doing field sobriety tests. If you have clients that are exceedingly intoxicated, and the case is going to have to plead out because of the evidence, it's very helpful when you have that type of evidence to show your client. And by the same token, though, you may have things that are significant on the tape that your client's not aware of that you pick up on. I'll just give you a real quick war story. I had a client at one time who just swore to me that he was totally innocent and the cops framed him. That happens all the time, as you all know. So I said, well, let's watch the tape together and see what happens. And the tape revealed he was so intoxicated that the police were actually afraid to take him out of the car because they thought he'd immediately collapse into the street. And they got him out, and it was embarrassing. He had urinated on himself, defecated on himself, vomited on himself. He was just a mess. So the police went to handcuff him, and they took his arm, and he just pulled his arm away. And the police just said, "Oh, no, you don't." And they came and they grabbed his arm and handcuffed him. When he saw himself, he was completely mortified and said, "Look, nobody can ever see this. I'm a businessman. I can't have this kind of stuff in public, or even the possibility of somebody seeing this and sticking it up on the internet." So I got the idea from him pulling his arm away that I'd asked the prosecutor to have the police charge him with resisting arrest based upon him yanking his arm away. Do it on a summons, which they did, and then when we came to court, he pled out to the DWI very quickly, and they dismissed the resisting arrest charge. And that opened up the door for me to get an expungement of the police reports and the videotape and all the other stuff that was associated with this. The drunk driving survived, of course, but that wasn't what he cared about at this point. He was mostly concerned about getting the police reports and such embarrassing evidence taken away and isolated as you could do through expungements. So, but I wouldn't have known that if I hadn't scrutinized the tape. And you've really got to sit down and talk to your client about it. He's got to see himself objectively and see what the rest of the world's going to see. Many times they don't want anybody to see it, especially family members or just members of the public sitting in the courtroom. Okay? By the way, do you agree with this? You think it's a bad idea? All right, just checking. Because I don't want to give you any bad information. If Michael says it's true, that's a good deal. All right. You've got to prepare your client properly for plea or trial, set their expectations, and remember, at the end, you got to keep RPC 1.2 in mind. That's the scope of representation. That at the end of the day, your client gets to make the final choice about whether he's going to plead guilty or not guilty, whether he's going to testify or not, and theoretically whether or not he's going to have a jury trial or not, although that decision is not in play in drunk driving cases. It's really not that much in play in New Jersey generally. But under RPC 1.2, the decision about whether your client's going to testify or not and whether he's going to plead guilty or not guilty, at the end of the day, is exclusively in your client. And you can cajole and beg and say, this is not in your best interest, and give them your best shot. But if they decide they want to go to trial, they're going to go to trial, okay? That requires you getting ready for this and get their expectations set. If it's going to be a plea, as most of these cases wind up, there's certain things you've got to make sure your client's prepared to deal with. And here's just a quick list. Let's talk about interlock device for a second. It's a hard issue to deal with, to do it properly. The judge, under most circumstances, when he orders that an ignition interlock device be installed, the order of the court in sentencing really is that you install it today before you leave the courtroom, that it remain on your car during the determinate term of your suspension, and then for an additional period of time after you get your license back, for the first offender between 6 months and a year, and for subsequent offenders between 1 and 3 years, okay? The only minor exception to this is for those individuals who are first offenders and have a BAC under .15. When the judge orders someone with a BAC under .15 to install an ignition interlock device, only then is it required that the ignition interlock device be installed at the conclusion of the suspension term, okay? That's the only time. For every other suspension, all the ones for first offenders over .15, every second offender, every third offender, every refusal, they have to be installed pretty much immediately, okay? But here's the problem you run into. If your client installs it immediately, he or she is going to be paying for the installation cost and the monthly fee to maintain the alcotest on either vehicles that he owns or vehicles that he principally operates, that he's not going to be driving. The people who are going to be blowing into the alcotest are the family members who are driving that car, the brother, the mother, the son, whoever it may be. And the only thing they did wrong was they know him. That's about it, okay? It can run into a lot of money if you're dealing with second offender, because you're going to say to your client, look, you got to pay for this for the next 2 years, even though you're not going to be driving. I'm sure your family will be happy to blow into it every 3 seconds to keep the car going. And then after 2 years is up, once you get your license restored, you can then you can drive, but you can't drive any vehicle unless it's equipped with an ignition interlock device, okay? So here's the ethical problem. It's not going to make any difference to the Motor Vehicle Commission if your client gets the interlock device installed the day before he applies for a license or the day that he comes out of the courtroom. It's utterly irrelevant. Motor Vehicles pegs the relicensing of the defendant to proof that he has an ignition interlock device on the vehicle today, all right? They don't look backwards to see whether or not it was installed during the determinate term of the suspension. Moreover, there's no enforcement mechanism in the judiciary or with the police to check to make sure that someone has followed through in installing the ignition interlock device on the vehicle. I don't see how there could be, because a lot of people don't even own any cars, okay? So with that in mind, what you could say to your client is, well, basically say exactly what I said. I don't want you to flout the order of the court. If you don't install the ignition interlock device, the likelihood of you being caught is extremely remote. If you do get caught, it's a disorderly persons offense. Motor Vehicles is not going to care until you're ready to get your driver's license back. At that point, you're going to have to show them proof that you've installed it on a vehicle that you own or principally operate. Okay? And by the way, in these examples I've been giving you, I've been talking about assuming the guy has one car. If he has 2 cars or 3 cars, it gets, very, very expensive very, very quickly. So you should prepare your client ahead of time in those instances where there's going to be an ignition interlock device, so he or she will be psychologically and financially ready to go forward with what has to happen. Everybody got that? Very important. All right. On surcharges. Tell your client that the surcharge is $1,000 a year. Tell them that it will be automatically billed to him or her at the amount of $84 a month. Explain that you can pay, if you have the wherewithal, you can pay 1 year's assessment ahead of time, but that's all you can do. So you get your first year's assessment of $1,000, you can send them a check for $1,000, and that's perfectly great. But then you'll have to wait, because the following year you go through the process again where they'll send you a new bill for $1,000. And then after that, for third year, you'll get another bill for $1,000. All right? In the absence of you paying it off in full, you pay it at $84 a month until it's all taken care of. Okay? Let them know that this is coming. I think the best way to approach liability insurance is just to tell your client flat out, you're going to lose your liability insurance. It's going to be canceled. Yeah, but I've had the same company for 20 years. And you could say to them, well, I'm sure they'll be very sad when they wave goodbye to you. All right? But you're going to lose your insurance. Explain to them that in New Jersey, if you have more than 7 insurance eligibility points, the insurance company can cancel you. Drunk driving by itself has 9, so that pretty much kind of gets you kicked out. You will be able to purchase insurance, but you can't do it in the voluntary market. You're going to have to go through the assigned risk program. So explain to them that they'll be able to buy insurance, but it's going to be much more expensive than they're used to paying. They may want to change their coverages or take whatever steps are necessary so they can still afford the coverage, okay? But you're doing your client a disservice by giving them any expectation that they're going to be able to maintain their insurance on the car. It's not going to happen, okay? And the fact that they have 2 or 3 policies with the same company, they've been there for years, it's not going to matter, okay? You've got to tell your clients that. Your client may have a cause of action arising out of the drunk driving case. He could have been setting a light and got clobbered himself, all right? Been injured or had all kinds of property damage. A plea of guilty to either drunk driving or refusing to submit to a breath test will trigger 39-6A-4.5. This completely divests you of any cause of action for personal injury, property damage, or pain and suffering arising out of the drunk driving case. You just have no cause of action. The only thing your client will be able to get in terms of any remuneration at all will be his PIP coverage. But apart from anything else, you have no cause of action. Now, you got to kind of recognize this going in, because if your guy was hurt bad and has a good cause of action, a lot of insurance on the other side, no liability issues, these are the cases you really got to fight hard to make sure that your client can maintain his cause of action. Because the battle is really with the civil case as opposed to the traffic ticket. But if you go into court and plead your guy guilty and not realize what the impact is going to be, no pun intended, you're doing your client a tremendous disservice, okay? I can't tell you about the immigration consequences. I don't know that much about it. I know that the Supreme Court of the United States has ruled that drunk driving is not an aggravated felony. I guess removal from the United States would probably be predicated upon being an alcoholic or have some type of involvement with alcohol that's unhealthy. I think they use the word alcoholic in the statute. This could impact an individual who's either lawfully in the United States on a green card, could impact somebody who's illegally in the United States and be subject to removal. I guess it would also affect you, or could affect you in terms of applying to become a citizen. The bottom line is, if you don't know the answer and your client is not in the United States lawfully, or he's not a U.S. citizen, you really need to have your client hook up with counsel to find out what the impact, if any, is going to be for the future. Okay. Now on IDRC, again, you get a lot of disappointed clients unless you get them set up properly. All right. If it's a first offender, there's a fee to pay. I think it's $150. The most important thing you can tell your client is you got to show up on time. If they say they're going to start at 8:30 and you show up at 8:30 in 2 seconds, they're going to lock you out and they won't let you in. Get there early. They'll get a letter from them telling them to pay the fee. I think they have to pay it 2 or 3 weeks ahead of time with a money order. They'll get a place to show up. Tell them to show up. If your client has a relatively low BAC and is kind of not an alcoholic, you may want to prepare your client for the interview that they're going to get and say, look, they're going to be looking for signs that you have a problem with alcohol. If this is an isolated incident and you were never, you haven't been drunk every minute of your day, every day of the week, you may want to explain to the IDRC people that you don't drink, you don't want to drink, you don't want alcohol in your house, that this was just an isolated incident. Many times, if your client can answer those questions satisfactorily, the 2-day detention period, 6 hours each day for 2 consecutive days, will be the end of their involvement. However, you've got to tell your client if there's a refusal or if there's an elevated BAC, and the cutoff in my experience has been 0.17, the likelihood of them wanting your client to go for some continuing outpatient therapy following the initial IDRC involvement is extremely high. So tell them that, so they'll be prepared for it. Explain to them that if they have the 2-day IDRC for second offenders, they're actually going to have to physically stay overnight. They have to stay for 48 hours. And this is in place of a 2-day jail sentence, because everybody has to get a 2-day jail sentence as second offenders. The statute allows them to serve the 2 days in the IDRC. So they're really serving a jail sentence, but explain to them, set up ahead of time. They're going to have to do 2 days, and the likelihood of them having to do a follow-up aftercare is high. For third offenders, they're all required to do, I don't know if it's 13 or 16 weeks, but they're all now required to do outpatient therapy. So if you have a third offender or somebody who's just about getting to the end of his suspension, he comes to you for advice, you got to say, you got to do it. There's no getting out of it. And you got to let your client understand that, you got 3 different agencies going on here. You've got the municipal court, you've got the motor vehicles, and you've got the IDRC. You've got 3 different branches of government, and they have no authority over each other. The IDRC operates independently, and motor vehicles is not in a position to overrule them or second guess them. They're not going to restore your client's driving privileges until the IDRC has signed off on it. And if it's contingent upon doing 16 weeks of outpatient therapy, your guy's got to do 16 weeks of outpatient therapy. What I'm kind of asking you guys to do is to go over this very carefully with your clients, because the last thing you want is a client who's disappointed, disaffected, feels he wasn't given good advice, accurate advice, or whatever else might be required. Can you guys see the importance of this? Very important. All right.
But we're required to do the 16 weeks.
Yeah, I think it's very important when you have that. Michael's raising an excellent point. I'll give you guys a little practice pointer. When the judge at sentence fills out the IDRC form, look at it, make sure there's nothing written down for the BAC. Okay, it may be that the BAC was 0.19. They eliminated it because of a Fourth Amendment issue or 20-minute issue or whatever it is. So if the BAC didn't play a role and your guy got a tier 1, make sure the judge didn't write it on the BAC on the form that's going to the IDRC. Because even though it was a first tier, they're going to send your guy to some outpatient therapy thereafter. And in terms of the young people, I don't know if that's a policy. I can certainly see it happening. Do you agree with me, though, that if you prep your client the right way, he may be able to avoid this?
Absolutely.
Okay. I don't see clients getting any advice from their attorneys at all. All right. Okay, this is an enormous error that I see come up, and it has devastating consequences for the defendants. We are in what's called a notice jurisdiction in New Jersey. And the notice requirement in drunk driving cases is not by statute. It comes through the case law. The name of the case is State versus Kent, like the cigarette. This is a decision that was written by Judge Sabatino in the Appellate Division. And it requires that if you are going to want the phlebotomist as well as the laboratory technician who tested your client's blood or urine to show up at trial for testifying purposes, so you can secure your Confrontation Clause rights under the Sixth Amendment and in conformity with Crawford versus Washington, you must put the prosecutor on notice ahead of time. Okay? If you don't, then you will be deemed to have waived your Confrontation Clause rights, and the blood or urine evidence, whatever it may be, is going to come in as an exception to the hearsay rule, either as a business record or a public record. Okay? So, kind of like know this going in. If you don't do it, it's a catastrophic error. Now, and I'll be curious to hear what you guys do. I know for myself, when I have a blood or urine case, I will put my demand right in my letter of representation, because you're supposed to enter your appearance and make your demand for discovery simultaneously. Okay? So I write a letter to the court and say, by carbon copy of this letter, I'm alerting the prosecutor of our appearance, demanding upon him or her the discovery, and putting him on notice that I want any witnesses associated with the testing of the blood sample and the taking of bodily specimens out from my client's body to appear and testify at trial. And I just kind of throw that boilerplate language in the middle of the letter, but I'm covered this way because I've complied with the mandate of the case law. Remember, this is purely case law. This is not statutory. All right? Here's the language out of Kent. So we get into a fight. This is what it's about. We deem it appropriate prospectively to require as a condition of our treatment of lab reports and blood sample certificates as testimonial documents that defense counsel provide reasonable advance notice to prosecutors that they wish to cross-examine the author of these documents at trial. In the absence of such reasonable notice, the defendant shall be deemed to have waived his or her right of confrontation. By analogy, such a notice demand requirement is contained in 2C 35-19. Now remember, that applies in drug cases. It doesn't apply to drunk driving. It's a Title 2C statute. That statute allows lab certificates attesting to the composition of CDS to be presented in court in lieu of the laboratory technician's live testimony, unless the defendant provides the state with advance notice of objection to the admission of the certificate and demands the technician's appearance at trial. Okay? So, all that together, if you don't put the state on notice ahead of time, you're going to lose your right to confront the lab tech and or the phlebotomist, and you'll be losing an enormous amount of very valuable evidence. And then by the same token, you may also have a situation where you're there for trial and nobody shows up, and that has been known to happen, and makes the trial very short. Okay? All right. On conversions, I want to talk to you about conversion of blood serum into whole blood. When a hospital does an analysis of blood taken for somebody who's been admitted for the purposes of diagnosis and treatment, they test blood serum, as opposed to the state police where blood is being tested for forensic purposes. They're testing whole blood. There is an appellate division decision called State versus Lutz, L-U-T-Z. I've given you the citation in your materials, and you'll notice that there's a footnote in the Lutz decision that tells you how to convert blood that comes from the hospital setting into the equivalent of BAC. Now, there's no reason for you to have a hearing when this occurs. I would just indicate to the court that the formula for doing this is set forth in an appellate division decision, a published appellate division decision that the trial court can take judicial notice of, okay? That should go a long way towards telling the judge that it's not necessary to have a hearing or expert testimony to come in to do this conversion. Let's face it, if you've got a blood case and the reading is on the margin, you're dealing with a 0.15, a 0.10, 0.08, the conversion of the blood serum into regular whole blood is going to be enormously important for your client. All right? Okay. There's Lutz, and you can see this is the actual wording of footnote 2 explaining to you how you do the conversion. Oh, one additional thing I just wanted to have you be sensitized to. Any forensic scientific testing, any scientific instrument is subject to margins of error. And again, when you're on the margin of 0.15, 0.10, 0.08, something where it's going to make a difference, you'll get back blood alcohol results from the state police of X, whatever it may be, but they will also give you a margin of error, similar to what you get in an election, in a poll. This is a margin of error of 1 to 3% or something of that nature. Make sure you concentrate on what the margin of error is and then reduce the reading to indicate that your client should get the benefit of the doubt on this margin of error, which the state police will give you in the report. It could make a big difference when you have a reading on the margin. Everybody got that? Very important. Okay. And I see so many attorneys who are just not familiar with this. They don't understand the significance of it, or they don't bother looking. Okay. I want to talk about blood samples and urine samples that have been obtained by consent. My belief is, and again, I'm just giving you my own personal ideas on this, that prior to the publication of Birchfield versus North Carolina in the summer of 2016, Birchfield versus North Dakota in 2016, that there was no ability in New Jersey to consent to give a blood sample. And by that I mean that someone who was arrested by the police for drunk driving was required to give a blood sample. It was going to be taken by the police one way or the other, either the easy way or the hard way. But you had no right to refuse to give a blood sample, okay? And I've put in your materials the cases that stand for that proposition. My sense is that the Birchfield decision from the United States Supreme Court has now changed that dramatically, that there is no constitutional right for states to demand that people arrested for drunk driving produce blood samples, okay? In fact, the Supreme Court struck down as unconstitutional all the implied consent statutes in the United States that required defendants to give a blood sample. They're all unconstitutional. The taking of a blood sample as a search incident to an arrest is not permitted under the Fourth Amendment. It's unreasonable. It requires too much of an intrusion into the human body. It is a search for evidence beneath the surface of the body. And its intrusiveness and the embarrassment associated with it are just too much for the court to say that it is reasonable under the Fourth Amendment. Okay? Now, that being the case, it puts in play the idea that defendants can now consent to giving blood in New Jersey. I don't think they could before, but they certainly can now. A couple things I want you to think about when you've got a blood case where there's consent is in play. Number one, the Attorney General has promulgated, as of December of 2015, a prototype form that is to be used by all the police departments in the state. And I don't think it's worked its way down to the local departments because I have not seen very many using it at all. It's a pretty good form in terms of accounting for the State versus Johnson consent waivers that are generally necessary in consent type searches, okay? Talking about, you have the right to refuse to give your consent, you have the right to withdraw your consent up until the time we start taking blood out of your body, okay? Now, if you have a form that does not have these Johnson waivers or has it badly, you've got to do a motion to suppress evidence and argue that the form was insufficient to put the defendant on notice as to what his rights were under State versus Johnson. Now, over and above that, I'm just by pure advocacy and nothing else. Double A, could you do me a favor? Could you go online and see if you can find Adkins' decision unpublished from the Appellate Division from earlier this year? State versus Adkins. Okay. There are 3 Adkins cases, one from the Appellate Division and one from the Supreme Court, that are both published. The third Adkins decision, which I'm asking him to find for us now, he'll give you the Westlaw site. I don't know if we can find it. It is an unpublished decision. All right? However, I think it is an excellent decision in terms of putting additional requirements on the state in a blood draw case where consent is in play. All right? So I'm going to suggest, once he can find the site for us, that you guys look at it if you have a blood draw case, because it's really good language. Now, again, it's an unpublished appellate decision. Some of the stuff in there I don't think is actually good law, but they say it. For example, one of the things they indicated, and they were critical of the state, is that they never explained to the defendant that he has the right to have an independent test of his own blood taken by somebody else of his choice. I don't know where they got that from. I mean, it's certainly not part of State versus Johnson. If they're getting it out of the implied consent statute, doesn't say anything. The implied consent statute deals with breath testing, not blood testing. But if the appellate division wants to open it up and make that a requirement, that's fine with me. I'll jump all over it. Have you seen this, Michael, by the way? You have? So you know what I'm talking about, right? Okay. Now, make sure, if you're going to be citing this case, that you comply with, I think it's Rule 1:36-3, which is the court rule dealing with citing unpublished decisions. But, if you can put it in there, it's very, very helpful in terms of what's necessary in a blood draw case, over and above the normal State versus Johnson guidelines. Okay? You've got to be very familiar with that. All right. Yeah, and here's the citation on State versus Johnson. Okay, the state has to demonstrate the voluntariness of the blood draw and the fact that the defendant knew that he had a right to refuse to give his consent. Be mindful, if you're doing a motion to suppress on this, that the burden of proof is by clear and convincing evidence. Okay, that's another thing most attorneys don't understand. It's a clear and convincing evidence standard when you're dealing with consent, and the burden is on the state to demonstrate that the consent was given to that standard. Okay. I'm going to suggest to you, and again, this is just a suggestion, that on urine samples, the prior case law allowing urine to be taken either as a search incident to an arrest or because of exigent circumstances, both of those have been blown out of the water as a result of Birchfield and the McNeely decision. So, for purpose of obtaining a urine sample, it seems to me the state's either going to have to get a search warrant or get the urine sample by way of consent. I don't know when you would ever have exigency in a urine case, because the metabolites that are in your system are going to be there for a relatively long period of time. We're talking about marijuana. Well, how far out would you go with marijuana, especially if you're dealing with an inveterate smoker? Would you say 2 weeks, 3 weeks, something like that? All right. And other substances, you're going to get prolonged time periods where the substance will show up in the urine. Again, it's leaching into the urine through the fat cells in the body. But it obviates or vitiates any argument of exigency, because the evidence is here now. It's going to be there tomorrow. It's going to be there the day after. The police have plenty of time to get a search warrant. It's not like a blood sample where the police are losing their evidence at the rate of 0.015% per hour after it's been completely absorbed into the body. Okay, you can't conflate the loss of evidence of that's in the bloodstream from blood versus evidence which is leaching into the urine through the fat cells of the body. The urine evidence is going to be there for a while, certainly long enough for the state to get a search warrant. Okay. Another error that I see is chain of custody, and I don't want you to put too much weight in chain of custody defects. If you see that there has been a defect in the chain of custody, please be mindful that it merely goes to the weight of the evidence. It doesn't make it inadmissible. Do we have a citation on State versus Morton? Morton, like the salt? Right, you guys write that in your notes. It's State versus Morton is the case. He'll give us the cite on it in a second. Morton is the New Jersey Supreme Court case that stands for this proposition. So the argument you're going to make to the court, if there's a break in the chain of custody, is not that the evidence is inadmissible. You're going to argue as to its weight. It becomes less impactful. It's entitled to significantly less credibility when there's been a break in the chain of custody. Okay? Don't argue that it's inadmissible per se, because it's not. All right? Okay. I want to talk the difference, by the way, we mentioned a moment ago about hospital blood and police blood. And beyond the idea of serum versus whole blood, there's something else going on you need to be aware of. And that goes back to Crawford versus Washington. Okay? Now, you think about blood that's prepared for forensically by the state police. The blood was taken by the police with the intention of it being used in the prosecution of a particular individual at some time in the future. So the testing of the blood sample by agents of the state is done specifically for the purpose of coming up with evidence to prove this individual guilty. All right? That is not the case when you're dealing with hospital blood. Hospital blood is not taken for that purpose. It's taken for the purposes of diagnosis and treatment of a patient in the hospital. Since the state police blood is taken for the purposes of a criminal prosecution, it is testimonial in the sense of Crawford versus Washington. And if it's testimonial evidence, you have a right under the Sixth Amendment to confront the person who drew the blood and tested the blood. Conversely, if the blood is not taken for law enforcement purposes, but rather for diagnosis and treatment, it's non-testimonial in the Crawford sense, and you don't have any Sixth Amendment right to cross-examine these individuals. You can certainly call them as witnesses yourself, but there is no Sixth Amendment issue in terms of having them appear, which means if the state wants to have the evidence go in as an exception to the hearsay, either as a business record or a public record, there's no problem with that at all. You don't have a Crawford Confrontation Clause issue when you're dealing with hospital-type blood, okay? So don't get mixed up about this stuff, okay? In other words, I wouldn't want you to just assume that you sent a letter to the prosecutor saying, I want you to produce the lab tech, that the lab tech works for some private hospital because they took the blood for diagnosis and treatment purposes. You're not going to get anybody to show up at trial. They're going to do it by way of affidavit or some kind of hearsay report, which is going to go in as either a public record or a business record. Okay? It's a fundamental mistake that a lot of the inexperienced counsel make when they're putting these cases together, which can have devastating impact. All right. This is another enormous error. Can I pick on you for a second? Let's pretend like 5 years ago when you were a very young girl, maybe 18 years old, all right? And the cops grab you one night for drunk driving, and you have a tongue ring in. So now you're in my office sitting there, and you want me to represent you. And I see you have a tongue ring in, and I say to you, okay, how long have you had the tongue ring? And you say, 2 years. Okay. Did you have it in the night that the cops tested you? Yes. Did the police ask you to remove it from your mouth? No. Okay. Okay. Now, the SOP for the police when they're administering Alcotest is to remove any foreign objects from inside the oral cavity. They obviously didn't either look or here just didn't take the necessary steps to remove it. So the defense you're raising in the case is one of procedure. They didn't follow the right procedure in administering the test, okay? They don't follow the right procedure, test is inadmissible. So far, so good? Okay. Now, what I'm telling all of you is, for me to put this defense on, she has got to testify. There's no doubt about it. She's got to take the witness stand. Has to. And the confusion that I see in the defense bar is a lack of fundamental understanding about the difference between your client testifying during an Evidence 104 hearing as opposed to your client testifying during the defense case. All right? So let's think about it for a second. I don't know why you would have your client testify during the defense case to begin with, but assuming that you do, you go in with the understanding that your client is going to be subject to cross-examination on any aspect of the case. Any. Okay? The 104 hearing is markedly different. Number one, the scope of cross-examination on the 104 hearing is limited to the scope of your client's direct testimony plus any other issues affecting credibility, okay? But more importantly, the case law makes anything that your client says inadmissible for any purpose at all, okay? In other words, whatever your client says is never going to be considered by the court as substantive evidence in the case. Never. Okay? The only way it would ever even be brought up is if your client decides to testify during the defense case and says something at odds with what he or she said during the 104 hearing. Under those limited circumstances, the testimony during the 104 hearing can be utilized for impeachment purposes, but it's never admissible substantively. Okay? Remember, we're dealing with an evidentiary hearing here, and the issue is evidentiary, not substantive guilt or innocence. So the point I'm trying to make to all of you is that there is no downside at all to calling her as a witness. Okay? There's nothing to lose there. You just got to remember to remind the judge and the prosecutor of the limited purpose of her testimony and the fact that it's not admissible, in any other way, apart from making a determination on the 104 hearing. Everybody got that? Very, very, very important. Don't conflate your client testifying during her defense case as opposed to testifying during your part of the 104A hearing. Okay? She has to testify. And you're going to have other situations that will come up where all the information related to some defect in the way the Alka-Test was administered is in your client's possession. I had a cell phone in my possession. I was texting on it during that time period, or I was receiving texts from my friend and responding to them. Okay? I mean, whatever the issue is, there are many times your client's going to have to testify in order to establish it. Don't be afraid to call your client to testify during the 104 hearing. Just be aware of what the limitations are of that testimony. Okay? Here's the little squib on it, and it's Rule 104A. 104D indicates that by testifying on a preliminary matter, the accused does not become the subject to cross-examination as to other issues in the case. Again, strictly scope of direct plus issues related to credibility. All right. Now, here's another gigantic mistake. And Bob was involved in a case, went to the appellate division, called State versus Wolf. It wasn't Samantha Wolf, it was some other Wolf. I'm not sure who was on the other side. It might have been Michelle Verno. I don't know. But Bob had kind of set her up. He knew he was missing some discovery, didn't tell the prosecutor. And she left out a document during the 104 hearing. Okay? So the prosecutor put all the proofs in. And then Bob stood up and objected when she had rested. It's, again, in the 104 hearing. And he complained that he didn't get this particular piece of discovery. And she said, "Oh, gee, I'm sorry, Judge, I have it right here. It was inadvertent. I'll give him a copy now. Can I please move this into evidence?" All right? And then when he complained about the piece of evidence she forgot to put in, she said, "Oh, Judge, look, it fell on the floor here. I'm sorry, I forgot. Could I reopen for the limited purpose, excuse me, of introducing this in evidence?" So what do you think the judge said? Duh. I don't know if it was Judge Switzer or not. But I can't imagine any judge in New Jersey who would not let a prosecutor reopen the case at that stage in the trial for the limited purpose of correcting whatever mistakes they made. And I have to think that all the appellate panels in the state would approve of that. Okay? It's just because they would. And they certainly did in the Wolf case. So the actions of the judge were not an abuse of discretion, and the defendant went on to be convicted. Okay? I want to suggest to you taking a completely different approach. And it can be done in conformity with an appellate division decision, again written by Judge Sabatino. Brendan Scher was the attorney on this. You guys know Brendan? You know him, don't you? Called State versus Campbell, like the soup. All right? Now, here was Brendan's theory going in. The state has a 104 hearing. They put in a bunch of documents. The judge accepts the documents as evidence and admits the results of the test by clear and convincing evidence. Okay? And the guy gets found guilty. On appeal, Brendan argues that the Constitution requires that each element of the offense be proved beyond a reasonable doubt. Well, one of the elements of the offense here was the BAC, and the proof of the BAC was not beyond a reasonable doubt. It was proof by clear and convincing evidence. Therefore, the state was allowed to secure conviction based upon evidence that was less than the required constitutionally under both New Jersey and federal law. Okay? And he argued to the court that under current New Jersey law, once a BAC is introduced by clear and convincing evidence, there is no mechanism to combat that evidence. There is no way to rebut a reading of .08 or greater what's been introduced in evidence. There just isn't any, okay? And I believed that at the time. When I was teaching, I used to instruct people about that almost verbatim. Now I got to give all that money back because I was wrong, as it turned out, but who knew? Judge Sabatino says, no, that is an incorrect statement of law. The fact that the judge admits a BAC reading in by clear and convincing evidence doesn't necessarily mean that the judge is going to find it proves the case beyond a reasonable doubt. The judge may doubt the strength of the evidence based on other evidence or something else that happens during the course of the trial. The judge might even, just reject it completely and find it not admissible. Okay, because his determination to admit the evidence was only interlocutory in nature. Now, in about 2 seconds, we're going to get into the exact language of Judge Sabatino in the opinion. But here's what I'm going to suggest you do, and benefit from my example. I've done this probably a half a dozen times, maybe more. I have never lost. So just do it the way I say it, and I'm hopeful you'll do as well as I have done. Or at least make out as well as my clients have made out. As I told you before, the dirty little secret is the prosecutors don't know what they're doing, okay? They don't take the time to properly prepare their cases. They're not all that experienced to begin with, and they make mistakes. Let's take an example we talked about before. They put the AIR in evidence, okay? And the AIR says that they utilized a simulator solution, serial number ABC123. The simulator solution certificate they put in evidence is ABC 567. It's not the right one. Okay. And you pick up on that. What do? Do you do like Bob Pinizzotto and object when the judge says, do you have any objection to the evidence going in? And give the prosecutor a roadmap to conviction? Okay. Knowing that the judge is going to let the prosecutor make the correction? How about this? Here's what you should do. Nothing. Nothing. And that's the problem. When you do nothing, it's hard to tell when you're over, when you're done. Don't do anything. If the judge says, do you have any objections? Say, Your Honor, it's the state's case. They can put in whatever evidence they think is appropriate, okay? Not taking any position at this point. Your Honor admits the evidence, you admit the evidence. Okay. So the evidence goes in. And now you wait. And you wait, and you wait. And the prosecutor rests, and then you either put a case on or you don't. It doesn't really matter. But at some point, you're going to rest too. And the prosecutor's going to rest. And the trial is over. And what you need now is to get a commitment from the judge that the proofs in the case are done. That all the proofs are going in, and you're not going to permit any additional proofs to come in. Okay? And you've really got to get a commitment from the judge on the record to that effect. Because you're going to say, Your Honor, I'm going to make some statements in my closing argument, and I don't want to have the prosecutor now move to open up the case again. Okay? At some point, even a speeding train has to come to a stop. If Your Honor tells us the evidence is closed, and I can make a closing statement. It's not appropriate for me to make a closing statement if you're going to let the prosecutor reopen based on something that I comment on in what is otherwise not testimony in the case, not evidence in the case. So you get a commitment from the judge that the trial is over. Okay? Now you bring up the fact that the prosecutor made this blunder. And your argument is that it is legally impossible for you to be convinced beyond a reasonable doubt of my client's guilt. Because the core foundational documents that are indispensable to you receiving them in evidence are in error. Now, there's a Supreme Court case, which I'll give you the cite on, called State v. Koropchak, where the New Jersey Supreme Court says, look, this is not like horseshoes and hand grenades. Close is not good enough. You either have them all or you have nothing. If you're missing one document, it's the same as missing all 6 documents, okay? So you say to the court, look, it is now time for you to consider this case beyond a reasonable doubt. It is not possible for you legally to consider my client guilty beyond a reasonable doubt because of this mistake that they have made. Okay? Now let's take a look at the language from Judge Sabatino in the Campbell case. You'll see what I'm talking about here. Defendant in the Campbell case presumes that once a trial court decides to admit Alcatraz BAC results in evidence, a finding of guilt is automatic, and there is nothing the accused can do to prevent that outcome. This is not so. A court's decision to admit proof into evidence against a party, even if it is over objection, does not preclude the party from disputing the strength of that evidence at the end of the trial. And before final judgment of defendant's guilt can be entered, the evidence must have shown beyond a reasonable doubt that he or she is guilty. Thus, although Alcatraz BAC results are admissible into evidence upon the proffer by the state satisfying Chun conditions to a clear and convincing degree, the state's ultimate burden at the end of the trial is more rigorous. After hearing all the testimony, considering all the admitted exhibits, the judge ultimately must be persuaded that the elements of the offense, including the defendant's offending BAC level, have been proven beyond a reasonable doubt. In this hypothetical situation, it is conceivable that a trial judge might conclude upon further reflection, in light of evidence as a whole, that the defendant's 0.08% BAC level was not sufficiently proven by the state beyond a reasonable doubt. The judge's earlier decision to admit the BAC proof, a ruling that is interlocutory in nature and can surely be reconsidered, does not prevent the court from doubting the strength of that admitted evidence at the end of the case. In fact, the court can even reconsider its previous decision to admit the evidence if subsequent development supports such reconsideration. To be sure, we're mindful that DWI defendants commonly do not hang back and save until the defense case at trial their competing witnesses and arguments challenging the prosecution's BAC results. Such a strategy may pose risk, perhaps depriving the defendant of a realistic chance to have the case dismissed at the suppression stage. Even so, regardless of the trial strategy that may bear on the actual flow of evidence, our conceptual point is simple and unassailable. I like that. Simple and unassailable. The court's threshold decision to admit Alcatraz results by clear and convincing evidence does not always indicate how the court ultimately will regard the same proof at the end of the trial when a more rigorous standard of persuasion applies. And there's the citation on Korobchak. Okay? Mr. Mayor, how are you today? Very horrible. How are you? So, did you get that case I sent you?
Yes.
Okay, that's the case you were looking for, right? Okay. Yeah, I couldn't think of it either. So, everybody with me on this? But you got to do it the right way. If you do it the way I'm telling you, there'll be nothing they can do about it except to find your guy not guilty. Or your guy be found guilty of a first-tier violation. That's assuming they have the evidence to support the first tier. Everybody got this down? Yes? Okay. Here's Wolf. And again, I just don't think the example of Wolf is the way you should be going on this. Now, another error is on discovery issues where you're standing up in court, excuse me, and the judge is trying to get a sense of how the case is going to play itself out, and the judge turns to you and says, all right, Mr. Michael, what discovery are you missing? All right. Well, in the old days, this used to cause a whole bunch of fights. All right. The rules of court have been amended to eliminate that question and the inevitable fight-causing answer. It's Rule 777G, and notice what the rule says here. If any discoverable materials known to a party have not been supplied, the party obligated with providing that discovery shall also provide the opposing party with a listing of the materials that are missing and explain why they have not been supplied. So if the judge asks you that question, you say, Judge, you're asking the wrong guy. You talk to the prosecutor. It's his responsibility to know what he sent me and what he's missing and provide me that list in writing. As it's my responsibility for discovery that I have not sent to the prosecutor to be aware of it and to provide the prosecutor with a list of it. Everybody got that? You don't have to get into this game anymore where the prosecutor wants you, or the judge has you paint a roadmap of for the conviction of your client. Okay? Now, if you're going to cite this rule, you indicate to the judge the rule was specifically adopted at the urging of the State Bar Association to do away with the situations where they put defense counsel on the spot. Got it? Not your job. Everybody's responsible for providing discovery to his adversary. Got it? All right. On HOLLOP orders. I know what Judge Gruccio said. I've read the case a million times. I just think that his sanction in the case to put in the HOLLOP order that the case be dismissed for failure to comply with a discovery order, I think it's a bridge too far. I think it's asking judges to do too much, especially in the drunk driving context, and it's probably unnecessary for you to get what you want anyway. So rather than if it's a discovery fight over some piece of discovery, let's say it's charging grafts in a blood case, and they haven't given it to you. They haven't, and you do a HOLLOP order. The HOLLOP order should say that the blood results are inadmissible at trial, okay? The likelihood is that's going to get you the same thing that you, for asking that the case be dismissed. It just gets you there in a more palatable way with the judge. Or if there's some police reports or things like that, or let's say you can't get Shun documents, you're going to argue that the results of the Alka-Test be inadmissible, all right? It's a more reasoned, rational way of dealing with these things. But at the end of the day, with the exclusion of that evidence, it's all going to work out fine for you. Everybody got that? Okay. There is a parallel court rule, by the way, with HOLLOP. It might be 777I. I think it is. Take a look at Rule 7:7-7I, which provides additional authority of judges to take action, sanction the other side for not providing discovery. So between that and HOLLOP, you should be in good shape. But it's a mistake to be asking for dismissal. It's not necessary. You're going to get it anyway. Sometimes less is more. On refusals, this is another mistake I see defense attorneys make all the time because they don't understand the interplay between the elements of drunk driving and the elements of refusal. So let's just talk about it for a second. The New Jersey drunk driving statute applies to every square inch of the state of New Jersey where the state exercises its sovereign jurisdiction. Now, typically, that's going to be everywhere except for military reservations and federal property that might be a fort or an arsenal. Might be there's a couple federal beaches around. I know there's one in Cape May. There's another one in Monmouth. Those are areas where the federal government exercises primary jurisdiction. The state doesn't really exercise sovereign jurisdiction over those areas. But for every square inch of the state where the state exercises its sovereign jurisdiction, drunk driving and driving on the revoked list can be committed, okay? That is not the case when it comes to refusal to submit to a breath test. It is not. The elements of refusal to submit to a breath test requires that the operation occur on a street, highway, or quasi-public area, okay? So if you're driving on purely private property, you're in your own driveway, your own garage, you're in a field that you own or something of that nature, it's not an offense. You're not required to take a breath test, okay? Garbin is the main case dealing with this particular issue, and it defines, it explains why there's this distinction between the drunk driving statute and the refusal statute, and also helps describe the definition of a quasi-public area. Think about a quasi-public area as property that's privately owned, but yet members of the public can legally access it. So, for example, the parking lot of the hotel where we are today, this is quasi-public property, okay? But, you know, your driveway at your house or a field that you own or something of that nature, it's not quasi-public property. People generally, members of the public are generally not permitted to go there. It's private property, okay? Now, how do you handle this when you have a situation where the operation of the vehicle did not occur on a street, highway, or quasi-public area? Well, you have to look and see what you got going. If there was a refusal to submit to a breath test, you have an affirmative defense that you can raise to the refusal charge, okay? And that is that the element of operation can't be proved because of the street, highway, or quasi-public area. Conversely, supposing that you don't have that, okay? Rather, the police read paragraph 36 to your guy and your guy took the test, okay? He wasn't required to take the test. There was no reason for the police to read in paragraph 36 because they didn't have any obligation to take the test. You file a motion to suppress evidence, and your argument is that the police made a mistake of law, and they made an unreasonable mistake of law, okay? Anybody looking at the statute and be familiar with the case law would know that under the circumstances of this case, no one was required to take a breath test. The police were wrong objectively. They made a mistake of law which is unreasonable. And your argument is that an unreasonable mistake of law will not justify prosecution for this type of offense. Okay? Now, this, if it works, is going to be dispositive of the case. It may get you something a whole lot better than you were initially entitled to. All I'm suggesting is that you recognize this when it comes up and then exploit it to the extent that you can. Everybody got that? Okay. One additional thing on curing refusals. This is just straight up black letter law. Don't waste your time. You can't cure a refusal under New Jersey law. So you're going to argue, well, yeah, but my guy changed his mind when they put him back in the jail cell and kept yelling to the cops he wanted to take the test. Doesn't apply, okay? You can't cure a refusal under New Jersey law. Bernhardt is the case. States for that proposition. All right, a couple of quick things on sentencing on step-downs. Remember, you can get more than one step-down in your life. That's the decision in the Revy case by the Supreme Court. Just got to make sure that you have 10 years, a full 10 years between offenses. Be mindful it's the date of offense that counts, not the date of conviction, the date of offense. So I'll give you just a typical example. A guy gets, the first time the cops grab him is 1980, and he's treated as a first offender because he is a first offender. The next time the cops grab him is 1991. Although it's his second offense, he has more than 10 years between his first offense and his second. He gets to be treated as a first offender. Then the next time the cops grab is 2004. Although this is nominally his third offense, he's had more than 10 years between his third offense and his second offense. He is entitled to be treated as a second offender on this occasion. In fact, it's not as entitled, it's mandatory. After that, all bets are off, okay? You can't benefit more than twice, but you can get 2 step downs in your lifetime, provided that the timing is right. Again, be sure to remember that it's the date of offense that counts, not the date of conviction. Refusals carry the same step down. It's not in the statute anywhere. It comes through the case law. State versus Fielding is the older case that stands for that proposition, and then a newer case, State versus Taylor, will give you a step down on related refusals. So to go back to our initial example, the first offense was 1980, the defendant gets stopped in 91. He is entitled to a step down on his drunk driving, but he would also be entitled to a step down on the refusal charge, the related refusal charge. Okay? But this is purely coming through the case law. All right? You got to know that through Fielding and Taylor. LORC relief is becoming less and less useful because there's just not that many people who are going into court pro se anymore in drunk driving cases, that's to begin with. And then on top of that, judges are doing a much better job in getting waivers out of those few people who go into court and plead out to drunk driving on a pro se basis. So LORC doesn't even begin unless you're dealing with a pro se plea. You never reach any other issue. That's the first part of it. It has to be pro se. However, it's still out there. It's still good law, and if you can utilize it, perfectly fine. I want you to understand that there is no statute of limitations on LORC applications, provided that you can make a prima facie pleading. Basically, if you can make a prima facie pleading that you're entitled to relief in a LORC application, the normal 5-year statute of limitations does not apply. Okay, but you got to make a prima facie case showing you're entitled to relief. It's, to that extent, it's much more beneficial than traditional post-conviction relief, which is very difficult to get around the 5-year limitation. Now, a couple of additional ways that you can attack prior convictions for purposes of eliminating them for enhancement of sentence. I want to talk about out-of-state convictions. All right, there is a provision in 39450A3 which says that if you were not convicted under a statute that was substantially similar to the New Jersey 39450 statute, you can eliminate that for purposes of sentence enhancement. Now, the burden of production is on the defendant. The burden of proof is clear and convincing evidence. However, once you establish that your client was convicted 15 years ago under an Arkansas statute, and you get a copy of that Arkansas statute that was in effect 15 years ago, and compare it to the New Jersey statute that was in effect 15 years ago, and you find that they're not substantially similar, the judge is allowed to ignore or discount the prior out-of-state conviction for sentencing purposes. I've given you 2 cases. Ripley is a case where the appellate division found that the statutes were not substantially similar and discarded it for sentencing purposes. And Zeichel is a case involving the New York driving while impaired statute, and that was substantially similar to the New Jersey driving under the influence. Okay. Now, I'm going to share with you my personal preferences for defeating prior convictions, okay? And the secret to it is to get the transcript of the plea colloquy. If you can do that, the vast majority of time you're going to be in business. You get the plea colloquy, you review it, and you will see, to your amazement, that most of the time, the plea colloquy is insufficient to support the guilty plea. There is no adequate factual basis. Remember, it has to be voluntary and knowing. Now think about what happens up in Superior Court, okay? You have to fill out this long form that's 40,000 pages to it, so that when the judge takes the plea, there is no question the defendant knows every single direct and collateral consequence associated with whatever he's pleading guilty to. The judges very seldom discuss anything with defendants before they take their plea, saying something like, Mr. Biddison, if you plead guilty today, do you understand I'm going to take your license for 6 months? I'm going to give you an ignition interlock device. I'm going to fine you $700. I could put you in jail for up to 30 days. You're going to pay surcharges. You might get thrown out of the United States. In other words, the judges don't go through what the defendant is facing before he pleads guilty. Normally, they just take his plea and then sentence him like they do for people with parking tickets. Everybody understand what I'm saying? That's not going to cut it in terms of the case law. There are 3 cases of recent vintage that I'd like you to be aware of: Perez, Tate, and Gregory. And I think you have the citations right here. What's interesting about those 3 cases, they were all published on the same day by the New Jersey Supreme Court, written by 3 different justices, all having exactly the same result and all dealing with the same legal issue. And that was the inadequacy of factual bases. And these were factual bases in the Superior Court, okay? It becomes much easier in municipal court where you don't have the plea form and those other things going on. Suffice it to say, if you file a motion to vacate a plea based upon the fact that there was no factual basis, it speeds up the process and makes it vastly simplified. It's not post-conviction relief. It's just a straight-out motion to vacate under Rule 7:6-2B. You present the judge with the plea colloquy. You say there's no factual basis, and these 3 cases, plus another one I've given you here, which is the Barboza case, says that when there is no factual basis, the plea gets vacated and the parties get returned to the status quo ante, okay? Now, the nice part about this is many times your client has already served out his suspension. He's done. He's got his license back, as a matter of fact. So that if the judge vacates the plea, assuming, and this is always unlikely, assuming that the state can go back and re-prosecute your guy, what's the point? If they retried your guy and convicted him, nothing's going to happen. Your guy has already completed the sentence. Sentence him again, he's done. He paid his fines, served out the suspension, What I'm just explaining to everybody is there's an enormous disincentive to retry these people after the plea has been vacated. But really, you don't care, because for your purposes, if the plea is vacated, you're going to be treated 1 degree lower on whatever offense you're looking at. If you're dealing with a 4th offender, you may be dealing with a 2nd offender all of a sudden because of a 10-year step down in between, okay? If you're dealing with a 3rd offender, you might be down to a 2nd. Or if you're dealing with a 3rd, if there was a step down, you got rid of the middle one, you might be dealing with a 1st offense. Everybody see what I'm saying? You will find that once you start looking, that the lack of a factual basis is going to be your most fruitful, and if you don't get it 65% of the time, you're not doing something right, okay? You're looking at the wrong judges. Everybody got that? So this is an enormously effective way of attacking these problems, and I'm going to suggest it to all of you. On mergers is another big mistake that everybody makes. No merging, okay? The judge starts talking about merger of offenses in court, ask him to not merge, to just dismiss it outright. The reason for that is, in our state now, penalty points survive the merger of the offense. So if your guy's got a 5-point speeding ticket and the judge says, I'm going to dismiss it by way of merger into the DWI, now your guy's going to get 5 points, where he didn't have to get any points to begin with, okay? No merger. Got it? Outright dismissal. On the back of the ticket, it says dismissed. It gives you 3 or 4 choices about how it was dismissed. If it checks off merger, motor vehicles will automatically assign points to your guy, even though the ticket got dismissed. You got to know this. This is a very common mistake the young attorneys make. No mergers, okay? Everything gets dismissed outright. And I've given you the cases that stand for that proposition. State versus Price is the case that actually motor vehicles uses to justify assigning points, penalty points, on tickets that get dismissed by way of merger. This is something that really should have been published, but they relied upon it to change their computer system. All right? On credit for time that your client spends in an IDRC approved inpatient facility against a jail term, you can do that. Your client can go in ahead of time and you can make an application for retroactive credit under an appellate division case called State versus Fife. I've given you the name of it up here. A practice pointer that you may want to do is this. If the judge is giving you a hard time because he wants to get rid of the case because it's more than 60 days old, say to the judge, look, my guy's in rehab. Why don't you do this? Issue a bench warrant for him and put like a $50 bail on it. By issuing a bench warrant and having a $50 bail, that will stop time running in terms of the 60-day target disposition for your guy. Your guy can then complete his program, and the minute he gets done, you post the $50 bail, and now the case is back on the front burner, and you go in and take care of it on the merits, all right? But having a bench warrant issued under these circumstances is a way of kind of taking the pressure off of everybody. And in terms of the credit for time served, again, you are entitled to it as a matter of discretion in those instances where you ask the judge ahead of time, okay? Fife is the case for that. On weekend jail, very difficult proposition these days. There's two cases on it. Grabowski is a law division case which says that periodic service of imprisonment is available pretty much for anything in municipal court. There's an appellate division case called Kotsef, which says that's as a matter of public policy, people who are facing mandatory jail in municipal court should not be permitted to do weekends. And they're talking in particular about drunk driving, third offender sentences. And finally, State versus Toussaint, which stands to the proposition that if the statute mandates imprisonment in the county jail, then the incarceration has to take place in the county jail, and other forms of incarceration are not appropriate. Of course, by the same token, if it doesn't say in the county jail, it just says, 30 days imprisonment, you can serve it anywhere. You can serve it in house arrest or, SLAP or one of these other alternative programs. The use of the word in the county jail out of this Toussaint case forecloses you serving your sentence anywhere else. All right? Finally, I want to bring to your attention, if you represent people who don't have the wherewithal to pay their fines and is holding you up from getting their license back, this statute will allow judges to eliminate fines, convert them to community service, forgive fines completely, and just kind of get rid of them because of changed circumstances in your client's life, such that it will eliminate bench warrants and other obstacles to your client becoming relicensed. Everybody got that? Very important step. Were you guys aware of this statute? It works for everything except the $250 surcharge that you get for the 39497.2. That's the only thing that's exempted from this. Every other type of monetary sanction, the ECCB and Safe Neighborhoods Fund, everything, not restitution, but everything else is subject to this and can be vacated, forgiven, converted to community service, that type of thing. All right? So, those are the main mistakes that I see happening. Was this helpful to you guys at all? Yes. You sure? Yep. All right. Everybody cool?